morning, friends. Today we are going to deal with a very important topic in the law of torts, and the topic is Violenti non-fit injuria. Violenti non-fit injuria. We know that a tort, you might have studied, is a civil wrong, independent of a breach of contract or a breach of trust. Now, in torts, when a person commits a tort, there are certain defenses which are available for him. So many defenses are there. So, a defendant who commits a tort, if he can successfully plead a defense in tort, then he will be absolved from the liability in tort. ഒരു ടോർട്ട് കമ്മിറ്റ് ചെയ്യുന്ന ഒരു വ്യക്തിക്ക് പറയാവുന്ന കുറേ ഡിഫൻസസ് ഉണ്ട്. ഈ ഡിഫൻസസ് വ്യക്തമായി പ്രൂവ് ചെയ്യാമെങ്കിൽ ഈ വ്യക്തിക്ക് ടോർട്ടിലെ ബാധ്യതയിൽ നിന്ന് he will get freedom. He will be absolved from the liability in tort. അതിൽ നിന്നൊരു മുക്തി കിട്ടും. അതിൻ്റെ ബാധ്യത അയാൾക്ക് ഉണ്ടാവില്ല. അതിനെയാണ് നമ്മൾ ഡിഫൻസസ് ഇൻ ടോർട്ട് എന്ന് പറയുന്നത്. Now, the major defenses in tort are Violenti non-fit injuria, inevitable accident, act of God, statutory act, etc. Now, in today's class, we are going to deal with the major defense, that is Violenti non-fit injuria or consent as a defense. Now, what is consent as a defense? Consent means when you are consenting for an act to be done, when you are permitting an act to be done, then you cannot later complain. നമ്മളൊരു പ്രവൃത്തിക്ക് അനുവാദം കൊടുത്താൽ പിന്നെ ആ പ്രവൃത്തിയെക്കുറിച്ച് കംപ്ലെയിൻ ചെയ്യാനോ കേസ് കൊടുക്കാനോ പാടില്ല. This is embodied in the maxim Violenti non-fit injuria, which means when you are voluntarily submitting for an act, then it is not a legal wrong. Then it is not an injury. Now, the rationale of this principle is that when you consent for an act, ഒരു പ്രവൃത്തിക്ക് സമ്മതം കൊടുത്തു കഴിഞ്ഞാൽ, then there is no injury in it. We'll go for an example. I invite my friend or someone to come to my house for a dinner. എൻ്റെ വീട്ടിൽ ഭക്ഷണം കഴിക്കാൻ ഒരാളെ ക്ഷണിക്കുന്നു. Now, as soon as he enters my house, can I file a case against him or can I file a complaint against him for trespass? അയാൾ വീട്ടിനകത്ത് കയറി കഴിഞ്ഞിട്ട് അതിക്രമിച്ച് കയറി എന്ന് പറഞ്ഞ് എനിക്ക് കേസ് കൊടുക്കാൻ പറ്റും. Or I send my friend or a servant or a driver to take my car to the workshop. So I send my friend with my car to the workshop. As soon as he go to the workshop, can I phone the police and say that he has stolen my car? വർക്ക്ഷോപ്പിലേക്ക് കാർ കൊണ്ടുപോകാനായിട്ട് ഒരു കൂട്ടുകാരനൊക്കെ പറഞ്ഞിട്ട് അയാൾ പോകുന്ന സമയത്ത് അയാൾ എൻ്റെ കാർ മോഷ്ടിച്ചു എന്ന് പറയാൻ പറ്റുമോ? No. Because all these activities we have consented. So once you have consented for an act to be done, then it is not a legal injury. It is not an actionable wrong. പിന്നെ അതിനെക്കുറിച്ച് കേസ് കൊടുക്കാൻ പറ്റില്ല. See, this rule with regard to Violenti non-fit injuria is applicable both with regard to torts of regarding property and also tort regarding persons. Torts regarding the body of a person or just like battery or assault. അപ്പൊ പ്രോപ്പർട്ടിക്ക് അഗൻസ്റ്റ് ആയിട്ടുള്ള ടോർട്ടിലും ഒരാളുടെ ബോഡിക്ക് അഗൻസ്റ്റ് ആയിട്ടുള്ള ടോർട്ടിലും രണ്ട് കേസുകളിലും വോളണ്ടറി നോൺ ഫിറ്റ് ഇൻജൂറിയ ഈസ് എ ഡിഫൻസ്. Now, it's like another example when you enter into a boxing ring for a boxing match. ഒരു ബോക്സിംഗ് റിങ്ങിൽ ബോക്സിങ്ങിന് കയറും. And you say that if you touch my body, the whole thing will change. I'll file a case. Can you do that? Or you enter into a fencing match and then you say that if you touch my body or harm my body, I will file a case. ബോക്സിംഗ് റിങ്ങിൽ കയറിയിട്ട് പറയാണ് എൻ്റെ ദേഹത്ത് തൊട്ട് കഴിഞ്ഞാൽ കളി മാറും, ഞാൻ കേസ് കൊടുക്കും. It cannot be done. But because as you enter the ring itself, you have consented for something to happen. Or slight pain or whatever it is. Now, in order to illustrate this, we will go for two cases. The first case in this category is a very classic case, that is Hall versus Brookland. Hall versus Brookland Auto Racing Company. Hall versus Brookland Auto Racing Company. This is one important case with regard to consent. Now in this case, you know what happened? There was a car race going on in a big stadium, just like the Sholavaram race or whatever it is. There is a big stadium where the car race is taking place. And on the boundary of that particular stadium, you have grills. And behind the grills, the spectators are watching what is happening. So some of them were there behind the grill. Spectators were there. In the last lap of the competition, one car collided with another car, slight collision with another car. And in the process, one car somersaulted and went over to the grill, and in the process injured some persons who were standing behind the grill. ഒരു ഓട്ടോ റേസിംഗ് നടക്കുന്ന ഒരു സ്റ്റേഡിയത്തിന്റെ ഗ്രില്ലിന്റെ പുറകിൽ ആളുകൾ നിൽക്കുകയാണ്. ഗ്രിൽ മീൻസ് സം സോർട്ട് ഓഫ് എ ബൗണ്ടറി, ആൻഡ് they were standing or sitting behind the grill. അപകടം സംഭവിച്ച കാറ് തലകുത്തി മറിഞ്ഞ് ഈ ഗ്രില്ലിൽ ചെന്നിടിച്ചിട്ട് പുറയിൽ നിൽക്കുന്ന ആളുകൾ ഇൻജേർഡായി. Now a case was filed by the injured person for negligence or whatever it is. We want compensation. Here the court held that this is a case of voluntary non-fit injuria. That is, when you go to watch a particular car race or anything like that, when some normal accidents, every accident is abnormal in the sense that there is a possibility of an accident, and if you are injured, then you cannot file a case. Now, there is another case, Bolton versus Tort. Actually, this is a case involving negligence, but many authors like PSA Pillai has included this also in the category of voluntary non-fit injury. The facts are like this. There was a big cricket ground. It was fenced. The cricket ground was fenced, and just near to the ground there was a particular small house. And it usually happens that when the ball from the ground, in rare situations, may go over the fence outside. Now here, one lady who was standing on the gate of her house, looking into the field, was injured by a sixer which was hit by the player, which went over the fence and landed into her house. Not house, on the gate. So actually she was not a spectator, but she was injured. Court considering so many factors like there was a fence all round and there is no negligence and all, held that this is also a case where impliedly she has consented to the risk. This is not the real aspect, but you can keep it in mind also. You can keep another fact Another situation where a person goes for a cricket match and is sitting in the stadium and a person hits a six and the six directly falls on your head. The ball falls on your head. Then you cannot complain because it is a case of Violenti non-fit injuria. All these things are there as a part of the risk of the watching a cricket game. So these are the two cases. Now there are four main principles with regard to Violenti non-fit injuria. The four main principles are: 1. Violenti non-fit injuria. First we studied about Violenti non-fit injuria. Now we are studying Violenti non-fit injuria, which means that knowledge will not amount to consent. Knowledge will not amount to consent. That is, നമുക്കൊരു അപകടത്തിനെ കുറിച്ച് അറിവുണ്ട് എന്നുള്ളത് കൊണ്ട് അത് സമ്മതമാകുന്നില്ല. That is first principle. Second principle is that the principle of Violenti non-fit injuria is not applicable when the consent is obtained by fraud. നമ്മുടെ സമ്മതം തെറ്റിദ്ധരിപ്പിച്ചാണ് ഉണ്ടാക്കിയതെങ്കിൽ ഈ Violenti non-fit injuria principle apply ചെയ്യത്തില്ല. That is the second point. Third point is Violenti non-fit injuria principle is not applicable in rescue cases. ഒരു രക്ഷാപ്രവർത്തനം നടത്തുന്നതിന്റെ ഭാഗമായിട്ടാണ് ഈ അപകടം സംഭവിക്കുന്നതെന്നുണ്ടെങ്കിൽ അവിടെ നമ്മൾ Violenti non-fit injuria ആ പ്രിൻസിപ്പിൾസും ഒക്കെ ആയിട്ട് പറയാൻ പറ്റില്ല. And the fourth principle is that Violenti non-fit injuria is not applicable to illegal unlawful acts. ഒരു കുറ്റകൃത്യം ചെയ്യാനായിട്ട് നമ്മൾ സമ്മതം കൊടുക്കാനൊന്നും പറ്റില്ല. ഒരു ഇല്ലീഗൽ പ്രവൃത്തി ചെയ്യാനായിട്ട് നമുക്ക് സമ്മതം കൊടുക്കാൻ പറ്റില്ല. So these are the 4 points which we have to study in the concept of Violenti non-fit injuria. We will study one by one. First is Violenti non-fit injuria. Violenti non-fit injuria means knowledge will not amount to consent. നമുക്കൊരു കാര്യത്തിനെ കുറിച്ച് അപകടം ഉണ്ടാവും എന്നുള്ള ഒരു അറിവുണ്ടായിരുന്നെങ്കിൽ, ഒരു കാര്യത്തിനെ കുറിച്ച് അപകടം ഉണ്ടാവും എന്നുള്ള അറിവുണ്ട് എന്നുള്ളത് കൊണ്ട് നമ്മൾ അതിനെ സമ്മതിച്ചു എന്ന് പറയാൻ പറ്റില്ല. When you have a knowledge with regard to a fact, it doesn't mean that you have consented it. For example, we know that lots of accidents are happening on the highways or roads, and there is a chance of getting an injury while walking on the road by 10%. 10% of the persons who are walking gets into an injury. We are aware. Let's consider. And when I am walking in the morning one day and I have an accident, can the other person say that, sir, you had knowledge that 1/10 of the person is always getting an injury while walking on the road, and you have risked it, and you have risked it, and thereby you have consented it? That is, the persons who are walking on the road has consented for any accident because they are aware that accidents, they are prone to accidents. Nothing like that. വഴി കൂടി നടക്കുന്നവർക്ക് നല്ല ശതമാനം അപകടം ഉള്ളത് കൊണ്ട്, നമ്മൾ വഴി കൂടി നടക്കുമ്പോൾ നമുക്ക് അതിനെക്കുറിച്ച് അറിവുള്ളത് കൊണ്ട് നമ്മൾ ആ അപകടത്തിന് സമ്മതിച്ചു എന്ന് കരുതാൻ പറ്റൂ? ഇല്ല. So the rule is that the fact that you have a knowledge with regard to a particular danger doesn't mean you have consented for it. This is one important principle, and that is embodied in the maxim Violenti non-fit injuria. So Violenti non-fit injuria and Violenti non-fit injuria. In Violenti non-fit injuria, you have two cases, very celebrated cases, very famous cases. I pay my homages to my professor, Dr. Dharmarajan, who was the principal of Kerala Law Academy, Law College, for having communicated or transmitted this case beautifully to us during our college days. So it's still ringing in my ears, the facts which he have given or explained to us. Now the first case is Smith versus Baker. In Smith versus Baker, see, I am a worker and I am working in a field in the sense that the field where I work. And above the field where I work, there is a big crane carrying big stones to and fro. That's every time I am working underneath, the crane is going on top of me carrying huge stones. I am aware that if there is an accident, the stone may fall down and I get injured. But I had no other go, because this is a place where the authorities have, or the employers have asked me to work. ഞാൻ ഒരു ഫാക്ടറിയുടെ പരിസരത്ത് വർക്ക് ചെയ്യുന്നു, ഇപ്പം ഫാക്ടറിയുടെ ഭാഗത്ത് വർക്ക് ചെയ്യുന്നു. ഞാൻ വർക്ക് ചെയ്യുന്ന സ്ഥലത്തിന്റെ മുകളിൽ കൂടി ഒരു വലിയ ക്രെയിനിൽ വലിയ കല്ലുകൾ സ്ഥിരമായി അങ്ങോട്ടും ഇങ്ങോട്ടും കൊണ്ടുപോയിക്കൊണ്ടിരിക്കുകയാണ്. ഒരു അപകടം പറ്റി ഇത് വീണാൽ എനിക്ക് അപകടം ഉണ്ടാവും എന്ന് എനിക്കറിയാം. പക്ഷെ വേറെ ഒന്നും ചെയ്യാനില്ല. I have to work there. So on the fateful day, there was an accident and the stone fell down and I was injured. When I filed a case for compensation, the argument on the part of the employers were that since you have the knowledge that there is a possibility for an accident, you have consented for the accident. So we are not to be blamed. നിങ്ങൾ ഇവിടെ വർക്ക് ചെയ്യുമ്പോൾ നിങ്ങൾക്ക് അറിയാം ഒരു അപകടം ഉണ്ടാവാൻ സാധ്യതയുണ്ട്. അപ്പൊ നിങ്ങൾ അതിന് സമ്മതം കൊടുത്തിരിക്കുകയാണ്. ഇറ്റ്സ് എ കേസ് ഓഫ് Violenti non-fit injuria. So you cannot further complain. Here the court held that the fact that I had information or knowledge that it is prone to an accident doesn't mean that I have consented for the accident. Just like you please make the stone fall and injure me. Nothing like that. So knowledge will not amount to consent. That is very important. So this classic case is Smith versus Baker. Now the second case, Dan versus Hamilton, is still more classic, or the facts are much more wonderful. Now this was something which happened on the eve of King Edward's coronation in England. ഇംഗ്ലണ്ടില് എഡ്വേർഡ് രാജാവിന്റെ കിരീടധാരണത്തിന്റെ തലേ ദിവസം നടന്നൊരു സംഭവമാണ്. When there is a coronation in England, it's a time for huge celebrations. People celebrate so much. They go from pub to pub. And the defendant, who is a deceased person in this case, Mr. Hamilton, had visited several pubs and he was drunk. അപ്പം ഈ കേസിലെ മരണപ്പെട്ട പ്രതിയായിട്ടുള്ള ഹാമിൽട്ടൺ പല പബ്ബുകളിലും പോയി വളരെയധികം മദ്യപിച്ചിട്ടിരിക്കുകയാണ്. Now after getting fully drunk with his friend Taunton, he was riding in his car. It was almost 11 o'clock in the night. 11 മണിക്ക് 11 o'clock in the night, fully drunk, he's driving his car. Now his friend was aware that he was drunk, and when they started the car, this particular person began to drive the car very rashly, very furiously, very rashly. On the way, a lady, Dan, asked for a lift. And of course, Mr. Hamilton stopped the car and asked her to get in. Taunton gave a word of caution. She got in. Then after she got in, he began to ride the car more rashly. Very high speed, very rashly. So after some time, Mr. Taunton asked his friend to stop the car, and he said that he is getting down because his house is very nearby. So he is getting down. And he also asked the other lady to get down, or hinted her to get down. മറ്റേ സ്ത്രീയുടെ ടോണ്ടൻ പറഞ്ഞു ഇറങ്ങുന്നതായിരിക്കും നല്ലത്, പറഞ്ഞില്ല, ഒരു സൂചിപ്പിച്ചു. Thereupon the lady commented, I mean Taunton said, you have more pluck, I think. You have more pluck, I think. I think you have more pluck. When she heard this, the lady retorted, see, what may happen will happen. What may happen will happen. That is, if something is going to happen, let it happen. This is how she commented. Then what happened? Hamilton went on riding the car at a very furious speed. There was an inevitable accident, and in that particular accident, Hamilton died. And Dan was severely bruised and injured. She filed a case against the estate of Hamilton, defended by his successors. അപ്പം ഇവിടെ ഭയങ്കരമായ ഒരു അപകടം സംഭവിച്ചു. ഹാമിൽട്ടൺ മരിച്ചുപോയി. ഈ സ്ത്രീക്ക് ഒരുപാട് അപകടം പറ്റി. അവര് ഹാമിൽട്ടന്റെ പ്രോപ്പർട്ടിക്ക് അഗൻസ്റ്റ് ആയിട്ട് കമ്പൻസേഷന് കേസ് കൊടുത്തു. Now, when the case came before the court of law, the main contention on the side of the Hamilton's estate was, this is a case of Violenti non-fit injuria. That is, this lady is aware that he is drunk, and knowing that he is drunk, she is again riding with him. So she had consented for the accident. But the court held otherwise. The court held that the fact that the lady had allowed or accompanied him in the car, knowing the risk of her injury, doesn't mean that she has consented for the act. The words used, if something happens, let it happen, doesn't mean that she means please kill me. That is only a knowledge, and that is not a consent. So this is the case of Dan versus Hamilton, but you can have a differing opinion. That is how the court analyzed it. Now, so this is the first part, that is, knowledge will not amount to consent. Having come to the second part, in the second part, that is, the second rule is that if the consent is obtained by fraud, then that consent is not a valid consent. You know that when you consent for something, you should believe in what is going to happen. If it is obtained by fraud, that is not a valid consent. You have studied in contract that the consent obtained by fraud or coercion or mistake, these consents are not valid consents. Similarly, in tort also and crime also, if a consent is obtained by fraud, then it's not a valid consent. Because in crime also you have consent as a defense, as a private, in the chapter general exceptions. Now, in order to illustrate this, it's better to go for criminal cases, because in criminal cases both tort and crime may come, and there are some cases to prove that a consent, if it is obtained by fraud, is not a valid consent. There is one case, I think, that is R versus Williams, wherein a music teacher had a sexual intercourse with a 16-year-old child who was studying under him. Actually, she allowed for all these things, believing that this is some sort of a therapy, or this is something beneficial to improve her voice. That is how he created some feeling in the child that this sort of an activity will improve her voice, and believing this, she consented. അപ്പോൾ ഒരു സംഗീത അധ്യാപകൻ 16 വയസ്സുള്ള തൻ്റെ ഒരു വിദ്യാർത്ഥിയുമായി ലൈംഗിക ബന്ധത്തിൽ ഏർപ്പെടുമ്പോൾ ആ കുട്ടിയെ ധരിപ്പിച്ചത് ഈ പ്രവൃത്തി എന്താ പറയുന്നത്, പാട്ട് പാടാനുള്ള കഴിവ് വർദ്ധിപ്പിക്കും എന്തോ ഒരു തരത്തിൽ. വി ഡോണ്ട് നോ, ഷീ ഈസ് 16-year-old. Here the court held that this is not a valid consent. The contention of the teacher was she had consented for the act, So this is not a case of rape. But the court held that here the consent is obtained by what? The consent is obtained by fraud. So when a consent is obtained by fraud, then it is not a valid consent. There is another case also in this category, that is Hegerty versus Heinz, where what happened was a person who was a lover had a sexual relationship with his partner. And as he was a carrier of venereal disease, he communicated the venereal disease to the partner. Later, the partner lady complained that, filed a case for compensation. Then the defense of the lover was that she had consented for the act. And then she said that she had allowed her act to be done, believing that there is no disease. And therefore his activity will amount to battery in tort, because battery means causing injury, disease, etc. But however, the court held that the whole fact in this case involved moral turpitude, and therefore we are not going to hear the case. So based upon the principle of extirpe causa non oritur actio, this case was dismissed. This again proves that but this was also being a case which can be noted with regard to Violenti non-fit injuria, even though it was not accepted by the court on a different ground, that is the whole fact is involved. Now we come to the third aspect. Third aspect is that with regard to Violenti non-fit injuria, there is another rule that in rescue cases this principle is not applicable. See, in rescue, certain persons are sacrificing themselves and trying to save another persons. In such cases, it is not justice to say that you yourself have taken the risk, so we are not going to give you compensation. നമ്മൾ രക്ഷാപ്രവർത്തനം നടത്തുമ്പോൾ നമ്മൾ മറ്റൊരു വ്യക്തിക്ക് വേണ്ടി നമ്മുടെ ജീവിതം തന്നെ റിസ്കിൽ പെടുത്തിക്കൊണ്ടാണ് അതിനു വേണ്ടി ശ്രമിക്കുന്നത്. അപ്പോൾ നമുക്ക് എന്തെങ്കിലും അപകടം പറ്റുമ്പോൾ പറയാണ്, ഇത് നിങ്ങൾ തന്നെ വരുത്തി വെച്ച വിനയല്ലേ എന്ന് പറയാൻ പാടില്ല. So this is the rationale of it. So in rescue cases, the principle of Violenti non-fit injuria is not applicable. With regard to that, there are two main cases. The first case is Heinz versus Harvoo. Heinz versus Harvoo. In Heinz versus, I am little fast because I am trying to make the class very compact. In Heinz versus Harvoo, what happens is that it happens in early England. So there was a horse cart, and in the horse cart there was a maiden and some children. The person who was driving the horse cart left the horse and went outside for some purpose. ഒരു കുതിരവണ്ടിയിൽ ഒരു സ്ത്രീയും 3 കുട്ടികളും ഉണ്ട്. ഓടിക്കുന്ന ആള് കുട്ടി കാട്ടിൽ നിന്ന് ഇറങ്ങിയിട്ട് പുറത്തോട്ട് പോയി എന്തോ കാര്യത്തിൽ. Now what happened is that a very mischievous child, കുസൃതിക്കാരനായ കുട്ടി, he threw some stones at the horse. And what happened? The horses bolted and started moving. ഒരു കുസൃതിക്കാരനായ കുട്ടി കല്ലെടുത്തെറിഞ്ഞു, കുതിരവണ്ടിയായിട്ട് പാഞ്ഞുപോയി. Now on seeing this, there was a policeman nearby. Sensing the risk, in order to stop the car, he jumped onto the cart. ഈ കുതിരവണ്ടി ഇങ്ങനെ പോകുന്നത് അത് തടയാൻ വേണ്ടി കണ്ടുനിന്ന ഒരു പോലീസുകാരൻ, he jumped onto the cart. When the policeman jumped onto the cart, he got injured. Now he filed a compensation with regard to the owners of the cart. A case of compensation was filed against the owners of the cart. Now the contention of the horse owners or the cart owners is that this is a case of Violenti non-fit injuria. When the cart is going, who told you to jump onto the cart and try to save them? It is none of your business. You could have watched it. If they have an accident, it's none of your botheration. You don't have any role in it. that was the contention. So this is a case of voluntary non-fit injuria. But this argument is not accepted by the court. The court held that this is a rescue case. And in a rescue case, the principle of voluntary non-fit injuria is not applicable. So that is one case. Now there is another case called Morgan versus Island. Morgan versus Island, a similar case. In Morgan versus Island, what happens is, there was a person who escorted a small child from the nursery to the school. He used to do that every day. One day, while escorting the child back to the house, on the way, he stopped somewhere to talk with the person or something like that. During that time, the child walked alone and tried to cross the road. And thereupon what happened? A motorbike was coming at a speed of say 20 kilometers. Not very high speed, but it was coming. So the child was crossing the road and the motorbike was coming. Seeing this, a passerby, a person who was standing nearby, he jumped onto the road to push the particular child away. And in the process, he was injured. സ്ഥിരമായിട്ടൊരു കുട്ടിയെ നഴ്സറിയിൽ നിന്ന് വിളിച്ചുകൊണ്ട് വരുന്ന ഒരാളുണ്ടായിരുന്നു. ഒരു ദിവസം അയാൾ ഇങ്ങനെ സംസാരിക്കാനായിട്ട് നിന്ന സമയത്ത് ഈ കുട്ടി സ്വന്തമായിട്ട് നടന്ന് റോഡ് ക്രോസ് ചെയ്യുന്നു. ഒരു മോട്ടോർ ബൈക്ക് 20 കിലോമീറ്റർ സ്പീഡിൽ വരുന്നു. ഇത് കണ്ട ഒരാൾ രക്ഷിക്കാൻ വേണ്ടിയിട്ട് റോഡിലോട്ട് എടുത്ത് ചാടുന്നു. അപകടം ഉണ്ടാവും. Now the contention, when this person who is injured files a case, the contention of the person in the motorbike was that it is this particular person who has jumped into the road and it is an act of voluntary non-fit injuria. So there should be a contributory negligence which is entirely different. So whatever that, the plea was a plea for voluntary non-fit injuria, but it was not allowed by the court. The court held that this is a rescue case and the principle of voluntary non-fit injuria is not applicable. So much with regard to the fact that with regard to rescue cases, this principle is not applicable. 2 cases. And the final thing is that no consent can be given to do an illegal or unlawful act. See, you cannot give a consent to a person to say that, please kill me. And the person is coming and killing me. No, you cannot give consent for a person to kill you. You cannot give a consent to a person to cut your arm. Or you cannot give a consent to a person to hide himself. He is a criminal or something like that. Or to hide contraband goods or anything like that. So, if it is a case where you are consenting for an illegal act to be done, then the concept of voluntary non-fit injuria is not applicable. Though this principle is not applicable with regard to commission of an illegal or unlawful activity. So these are the main principles with regard to voluntary non-fit injuria. There is some cases which are being repeatedly asked for the examination in your problems, like the Dan versus Hamilton. So that is voluntary non-fit injuria, that is consent as a defense. Thank you.